Major breaking Second Amendment news. The Second Amendment case of Todd Vander Meide versus Cook County, Illinois, also known as Chicago, is moving forward with a big oral argument this week in Chicago about whether or not the Cook County tax on guns and ammunition is constitutional under the Second Amendment. Spoiler alert, it's not. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of The Four Box, a diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist in 2 separate 2024 Gundy Award categories. Category number 1, top male influencer in the Second Amendment space. Category number 2, top voice of the Second Amendment. I'm honored to be a top finalist in both categories. All right, folks, Todd Vander Meide versus Cook County. Todd Vander Meide versus Cook County, Illinois. Major oral argument as to whether or not Cook County's tax on guns and firearm sales is constitutional under the Second Amendment. As you know, Cook County is basically the city of Chicago, though it's technically the county out there. The county is the defendant. The argument is this Tuesday, and the question is whether or not the Cook County tax on guns and ammo and the like is constitutional under the Second Amendment. Again, we don't know what these judges are going to do because they're based in Chicago, and who knows what they're going to do when it comes to our rights. But here is why I think the Second Amendment should prevail and this gun tax should be struck down. To begin with, the most fundamental rule is we know that under the federal Constitution, it's black letter law, not just under the federal Constitution, but also actually under the Illinois Supreme Court's precedent, that a targeted tax that singles out a constitutional right is unconstitutional when it's singled out for special taxation of some sort. The most famous and obvious precedents by the United States Supreme Court itself is, of course, the decision in Minneapolis Star from the 1980s that said a 4% tax on the use of paper and ink was unconstitutional. Now, mind you, for those of you who like to play games, meaning on the anti-gun side, and make references to like ammunition is not mentioned by name in the Second Amendment, i.e. the right of the people to keep and bear arms shall not be infringed. There's no reference specifically to the word ammo. Well, guess what? Doesn't matter, of course, they're ancillary rights. We know in the Minneapolis Star-Tribune case that paper and ink are protected under the First Amendment, and a specific tax on paper and ink was unconstitutional, even though the words paper and ink do not appear in the First Amendment, which speaks to the right of the free press and the right to free speech. So anytime people make reference to something that's not expressly in the text of the Second Amendment, just remind them that, of course, there are other rights that are implicit in that are covered no different than ink and paper are covered by the First Amendment. So with that said, we know the Minneapolis Star-Tribune case should be a clear winner alone, but then we also have additional Supreme Court authority in the Harper versus Board of Election case from the 1960s that struck down a $1.50 poll tax, again on the grounds that a targeted tax that singles out a constitutional right is simply unconstitutional and not allowed. Because once you open up the door to taxing constitutional rights, nothing prevents people from putting a tax on your right to an attorney, your right to a jury, putting a tax on your ability to go to a church and say mass or engage in mass or any of these things. So obviously they're not going to open up the door to this. And of course we understand that textually the right of the people to keep and bear arms shall not be infringed. If you put a tax on it, that is something that hinders the ability to keep and bear arms because you're making it harder to do because you're imposing financial burdens on it. So beyond that, though, this should also be a slam dunk case because of a decision by the Illinois Supreme Court. You heard that right, the Illinois Supreme Court. Now, granted, this was a Supreme Court decision by Illinois before the current Pritzker blessed two picks got on the Supreme Court of Illinois. But with that said, it's clear precedent. They struck down many years ago a $10 tax on marriage licenses on the grounds that a $10 tax on marriage license violated the Constitution because, again, it singled out a right, i.e. the right to get married, with a tax, and thus it's unconstitutional. So not only should this judicial panel, I think there's 3 judges, but I could be wrong on that, maybe there are 5, but whatever it is, the number of judges on the 1st District Appellate Court there in Illinois should take heed and notice of both the Supreme Court precedent at the federal level as well as the Illinois Supreme Court precedent in the marriage license case of $10 being unconstitutional under the state constitution. But I've taken a look at some of the papers here submitted by Cook County County, and they're basically, of course, trying to justify the lower court decision of the Illinois State Trial Court to say that this law, because the trial court upheld the constitutional or unconstitutional tax as I see it in the case, and they specifically said, well, it's been upheld before, but one of the problems of the trial court's decision that upheld this tax as constitutional is that it relied upon an earlier case called Guns Save Life. This first case of Guns Save Life held that firearms and ammunition taxes don't touch fingers with the Second Amendment, and they don't implicate the right. But the problem there, from a legal perspective, is that they relied upon pre-Bruin decisions and simply talked about how that there's core Second Amendment rights and non-core Second Amendment rights, and they played that tiers of scrutiny game that a lot of anti-gun courts played before Bruin to try to say that certain fundamental rights are important and certain Second Amendment rights are important and other Second Amendment rights are not important. Bottom line is they tried to interest balance away our rights, and the Supreme Court in Bruin came back out and says, you guys cannot do that. Now, the trial judge in this case of Todd Vander Meide versus Cook County, again, re-embraced the pre-Bruin decisions, even though those decisions had already been abrogated or destroyed, if you will, by virtue of the Bruin decision that really undercut and wiped out the fundamental premise that there's different tiers of scrutiny and different levels of protection for Second Amendment rights, which the U.S. Supreme Court says no can do. All Second Amendment rights are protected equally under the text first, burden shifting to the government, and then the burden on the government to come forth with historical analog laws. They're simply not going to be able to do it in the context of this case, even beyond the fact that it's clearly unconstitutional to single out a constitutional right with taxation. Even beyond that, there's certainly no historical justification. Going back to 1791, the year the Second Amendment was adopted and ratified and effectuated to justify taxation on guns or ammunition. Even if you just do a Bruin analysis, they're never going to get to where they're going to get. So again, in addition to the fact you have Supreme Court precedent at the federal level, state level, and a misunderstanding of the role of Bruin in a post-Bruin world by the trial court, and of course you throw in the fact that you cannot balance away our rights. And of course, there's no historical analog taxation law dealing with guns and ammunition at the time of the founding. This should be a slam dunk case for Todd Vander Meide and the Second Amendment plaintiffs. But of course, I'm sure it will not be that easy because you're dealing with Chicago, and those Chicago politicians undeniably, or my guess is, I don't know the judges, I don't know their names, but my guess is that the judges that are going to sit on this panel are probably going to be your off-the-shelf, dyed-in-the-wool liberal anti-gunners that are plucked out of the city of Chicago, and you know where they're going to come out on this. It doesn't matter what the law is. It's not like exactly Chicago's the best, the most well-run city on the planet, although they've done a very good job in, really limiting violent crime in that city with all their gun control laws. But basically, Chicago is not exactly the best and the brightest when it comes to how they run that city. I think the record speaks for itself. Nevertheless, I'm not here to beat up Chicago, because I feel bad for all those Bears fans that have to keep losing to Green Bay. But again, that's neither here nor there. But let me continue on. The only other observation that sometimes we see in these tax cases is the government likes to try to conflate two concepts, a tax on the one hand with a fee. So I want to be very clear I'm going to make this easy for you right here and right now. A fee is constitutional usually. A tax is not. A fee and a tax are not the same. What is the difference? Constitutionally, a fee is something that you pay to the government to cover the cost and only the costs of a service. For example, if you go to Yellowstone National Park and pay, let's say, a $10 admissions fee to go to the park, that is okay and constitutional if the cost of the cost to the Park Service of providing the various services, trash removal, fire prevention, whatever it is, if the cost to the park of having you go to the park is $10, they're allowed to charge you a $10 fee. That is not considered a tax, because all you're doing is really reimbursing the government in that instance for their actual cost of providing the service to you. Those fees are okay. What is not okay are taxes. Taxes are different than fees in this context. Taxes are where you're charged something that has no relationship has no relationship to, or the amount you have to pay is over and above the cost to the government of providing you the service. So for example, let's say for the sake of argument, it costs them $10 for a police department to run your fingerprints through a NICS check or through a background check, whatever. You're just making this up here. Okay, it costs them $10 in police time. They can charge you legally, odds are, $10 for that because it's costing them $10. You're simply reimbursing them for their cost, which is $10. What they're not allowed to do is charge you $200 for something that costs them $10 and then pocket that $190 difference between the $200 charge and the $10 cost of providing the service, because that surplus of $190 would effectively be a tax that the police, for example, could use on other stuff, like maybe putting gas in their cars or paying for new bubbles on their vehicles or whatever. So that's the key. Now, inevitably in these tax cases, you will see the anti-gunners and the government arguing that all these things really are is some sort of a fee and not a tax. So you can bet your dollars to donuts that somehow in this argument on Tuesday, on January 21st, out there in Chicago, you're probably going to see a lot of back and forth, I'm guessing, about fees versus taxes. I could be wrong. We'll see. We'll try to bring you up to speed after the argument takes place. But anyway, keep your eyes peeled for this case, because this is the kind of case that could find its way up to the U.S. Supreme Court on taxation associated with gun-related rights under the Second Amendment. So keep your eyes focused on this case as it winds its way through the Illinois state court system. And we wish Todd Vandermeide good luck and Godspeed on his mission, and hopefully he gets all the way up to the Illinois Supreme Court, and from there he can get a decision from the United States Supreme Court itself that knocks out these ridiculous anti-gun taxes once and for all. We have a lot of work to do in the Second Amendment community, but I'm optimistic we're going to get to where we need to be bit by bit. It's a war, will never end, but we keep winning these battles. And again, I'm just bringing you up to speed on battles that are forthcoming that you need to keep an eye on. So there you have it. All right, folks, hope you learned a little bit something here today. Make sure you subscribe and resubscribe. People keep getting knocked off, so make sure you subscribe and resubscribe to this channel. Don't forget to follow me on X at 4 Boxes Diner. And of course, we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.